Good evening, this is John Milburn for Laws 13010, Evidence and Proof. We're into week 11. This week we're dealing with opinion evidence primarily. And opinion evidence caters for expert evidence. It also caters for lay evidence. And when it comes to the expert evidence, we need to be aware of the role of the Uniform Civil Procedure Rules in terms of the evidence that might be presented in civil cases. So it's not just the Evidence Act tonight for Queensland, it's also the UCPR. And in particular, some of the rules that relate to the provision of expert evidence, which is around the Rule 420 mark beyond. In terms of the Commonwealth, we have the Evidence Act, the Uniform Evidence Act as usual. In terms of the breakdown, the opinion evidence for an expert is usually provided in a report. We sometimes talk about an expert's conclave, which is where two experts will meet and come up with a common report. Otherwise, there are restrictions on the use of experts. There are cost penalties that apply if you have more than one expert where there was no need for more than one expert. And there are rules about the way in which the report is provided. It has to be, a report is the evidence in chief. You can't call an expert to give evidence in the witness box, although the witness can be cross-examined, of course. And the other thing is that the report that I'm referring to, which is going to be used in evidence in a civil trial, needs to be provided a certain number of days before the, after the end of the pleadings. From memory, it's 90 or 120 days. And if you're going to rely on late expert evidence, then you need the leave of the court. So there are a few rules that we need to consider in terms of expert evidence, which is expert opinion evidence, really. Now, it's not just the experts who are able to provide an opinion when giving evidence. Lay people can also provide an opinion, so we call that lay opinion evidence. And it happens regularly, much more often than you'd probably think, because we don't necessarily see the evidence that is being provided by the lay witness as being opinion evidence. But there are some circumstances where formally lay people can provide their opinion. So I know what you're thinking. Right on day one, we said you've got to provide evidence which is based on your own five senses. You're not allowed to provide opinion evidence. And here I am in week 11 saying, oh yeah, sometimes we can. And sometimes what you perceive to be evidence from their own five senses is arguably opinion evidence. So we'll talk about a few of those things tonight. Vivian, Tegan, thank you so much for joining us. You've been stalwarts, and it's great to have someone here joining us for these live sessions. Usual rules apply. I won't pick on anyone, but if you have any questions, please unmute your microphone. Feel free to ask a question, make a comment. And Samantha's joined us, great, another regular. Say hi, Samantha. And if you have any questions, please use the chat. Yeah. All right, thank you, Samantha. All right, so let's talk about opinion evidence generally. So the standard rule is that a witness called to give evidence is not entitled to proffer an opinion. So we know that. The general rule is that the witness, expert or otherwise, is required to provide facts to the court, and the facts are those things which they have seen or heard or touched or smelt, etc. So what are we talking about when we talk about opinion evidence? We're really talking about someone who has formed an opinion and wants to present that to the court to establish proof of a certain thing which is based on that opinion. And let's talk about experts firstly. There are a couple of rules that you need to consider when determining whether someone can in fact provide expert evidence. Feel free to jump in if you know the two things that I'm thinking about here, the two crucial questions that you need to consider when determining when someone is able to give expert evidence. All right, so number one is, does the purported field of specialist knowledge actually exist? I mean, we can't have an expert, can we, if there is no field of knowledge? So if someone came to court apparently to give evidence in relation to some obscure um, fact, then if you're on the opposing side, you're entitled to say, we challenge that evidence on the basis that there is no field of expert endeavour or special knowledge in relation to this particular issue. The second question is, if so, if there is in fact a field of specialist knowledge that does exist, is the proposed witness sufficiently versed in that field? Now, that usually means having some credentials, which is academic vigour, or academic interests, but it may be that sometimes a person has certain expertise, but not necessarily in the specific field. So if you're going to challenge an expert's evidence, then you might think about whether this, for example, doctor is sufficiently expert to provide an opinion in relation to, for example, the effect of a knife entering the body. And you may say, well, that's not that's a very specialised field. And for example, a podiatrist, probably not a doctor, but someone who's in the medical field, say a dentist, for example, can't come along and give evidence in relation to the effect of wounding. So it's not just a matter of determining whether there is a special field, but also whether the individual can give specialist knowledge within the context of that field. So that's expert evidence. The second is lay opinion, and we'll talk more about this shortly, but what we're really talking about is someone who wants to provide an opinion. Now, it's not always obvious. For example, let's say this. Picture yourself in the witness box. You wish to describe someone, and under examination in chief, the prosecutor says, all right, so you saw someone, can you tell me something about that person? Now, I'll bet one of the first things that you're going to talk about is the person's height, their weight, perhaps the colour of their hair, their colour of their skin, with their gender. You might talk about their age. Now, these are all things that are pretty basic, aren't they? I saw a young fellow, think back to the exercise when you were cross-examining me, or examining me as the case may be, during that exercise. People were asking questions, who did you see? Can you tell me about him? Well, I saw a young fellow. He was the passenger in the motor vehicle. He was about 70 kilos. He was about 180 centimetres tall, etc., etc. Now, what do we say about that? Is that actually direct evidence, or is it actually opinion evidence? When you think about it, arguably it's my opinion, isn't it? My opinion was he was about 180 centimetres. I didn't measure him. He was about 17 years of age. That's arguably my opinion. Then there were questions, look, did he look, and can you tell me about how he appeared? And I might say, well, surprisingly, he didn't appear frightened, or he did appear frightened. There was a woman next to me, and she appeared to be frightened. I mean, is that really me giving an opinion? Or should I say, there was a woman next to me, and I noticed this about her facial expression. Now, this is really hard. Try and explain by reference to the muscles in a face that someone appeared to be frightened. Their eyes grew in size. They start, they move back. I mean, in the end, you try and describe it, and then the question will be, what? So you think the person was frightened? Yes, they were frightened. So there's a fine line between what is actually you giving evidence from your own senses and an opinion about what you saw. The car was red. The car was travelling at about 60 kilometres an hour. These are all, in a way, opinions. So we let those things go all the time, otherwise we'd never get a trial finished. Okay, so let's go back to expert reports and witnesses. So only experts can provide an opinion in relation to the field of expertise with the intention of proving that which they say as an opinion as being fact. Now, it doesn't mean that because an expert says something in a witness box or something in a report that it must be accepted as the case. The judge, the court, still remains the arbiter of fact. So this is still only evidence. We don't have a situation where the expert runs the trial or concludes the guilt or otherwise of a matter. It's still for the court to determine. So when you're in a court situation, you need to be prepared to argue whether some expert evidence is appropriate, if it's not appropriate, and even if it is let in, whether it should be considered and acted upon by the court. In terms of what might be appropriate expertise for giving evidence, sometimes it's hard to determine whether it's actually a specialist field of knowledge. So in your text, do you remember that case of Wheel against Bottom, 1966? That was the case involving the expert giving evidence about a motor vehicle skidding on a wet road. Now, here's the distinction. If someone was simply a layperson giving evidence that they saw the car skid, the road was wet, we'd let that through. And we'd probably have some idea of what that meant. And they say, you know, the tail spun out, etc., etc. But in Wheel and Bottom, they allowed an expert who was actually a truck driver who gave evidence in relation to the special dynamics of an articulated truck on a tight bend on a wet road. So that was allowed because it was a special type situation. So I guess the point that I'm making is it's a fine line and you need to be mindful of that. I guess another thing that's really contentious is experts giving evidence about human behaviour. Now in your text, there's some examples of where the court said expert evidence is not appropriate when the expert is coming along to tell us the effect of on a young man of being told that his girlfriend had been unfaithful. We don't need an expert to tell us that he's going to be upset. And the court said we're not allowing that as expert evidence because, and we're leaving that really for the jury to determine, because issues to do with emotional attachment are part of the human experience. Another case was in relation to the trial court disallowing evidence from a family services officer to comment on the behaviour of sexually abused children towards their abusers. So those sorts of cases are such that they give an example of what the court would not be prepared to tolerate under the guise of expert evidence. The Queensland Evidence Act now touches on this in one sense. If we go to Section 9 of the Act, which is under the heading of Part 2 Witnesses, it deals with the presumption as to competency. So you'll recall that the general rule is that every witness is presumed to be competent to give evidence, but sometimes it may be that a person, including a child, is under scrutiny in terms of their competency either to give evidence, which is Section 9A, or competency to give sworn evidence, which is 9B. So the court is entitled to hear expert evidence in relation to a person's ability to give evidence or give sworn evidence, and we refer to Section 9C of the Evidence Act 1977, which provides in 9C Part 2 that expert evidence is admissible in proceedings about a person or child's level of intelligence, including their powers of perception, memory and expression, or other matters relevant to the child or person's competence to give evidence, or give evidence on oath or give reliable evidence. So there used to be rules about children almost being deemed to be incompetent to give evidence. It was even worse than that. I won't go any further. It dealt with it to do with women. I mean, it's just bizarre things now. But in terms of any challenges to the competency of a person to give evidence, think about Section 9 and the basis upon which experts can be called to give evidence in that regard. Here's a common situation. Just get you to think about this. An expert is called to the stand. The expert gives expert opinion evidence, and you cross-examine the witness and you say, well, is that your opinion or did you read it in a textbook? And the expert says, well, I read that in a textbook. Are you entitled then to say, objection, Your Honour, that's hearsay. This is not really this expert's opinion. It's simply someone rehashing material, which is effectively hearsay. If you want the expert, you need to call the author of the book. What do you think? If you're watching this as a recorded session, just pause, think about it for a sec. Yes, Samantha.
Well, would it depend on what they're calling them for? Because aren't they calling them for the interpretation, their expert knowledge or expert understanding in interpreting that book or that passage?
Yes, I think that's the key to it. Even though they may not be the author, the rule is that if they effectively adopt what is said in the textbook, then it becomes part of their expert opinion. I mean, if they merely refer to it, that's probably not enough. But if they refer to it and say, I adopt that passage from the author's Smith and Brown textbook, page 27, then that becomes their opinion. That becomes the expert evidence. So good on you, Samantha. That's right. Okay, I'll pose another thing for you. Have you heard of the ultimate issue rule? Has anyone heard about that? Okay, the ultimate issue rule. I'll give a simple example. It comes down to this. An expert goes into the witness box and the prosecutor says, all right, well, tell us your opinion. You know, is he guilty or not? I mean, that's really the ultimate issue. That's the issue for the jury, isn't it? The general rule, and certainly at common law, is that experts are not allowed to give evidence about the ultimate issue in a particular matter, whatever that might be. So that's the general rule about not giving evidence as an ultimate towards the ultimate issue, rather. Sorry, Vivian.
Yes, I was just going to ask. Sorry to interrupt you. The Anita Kobe case. Because there was going to be an ultimate issue. I think evidence was not allowed to be admitted because they were going to question the mental state of one of the accused persons.
I'm just not familiar enough with that to be able to comment. Sorry, Vivian.
Oh, okay. Sorry. I think it happened in South Australia some years ago. They keep showing it on Crime Channel.
Okay, I'm not familiar with that one, but that sounds good. That might be a question for you, crew, but thank you.
Thank you.
So, right, so the ultimate issue. In Queensland, that's still the rule, which is the common law rule, but have a look at the Evidence Act 1995, the Commonwealth Evidence Act, Section 80, which has basically abolished it. It's very simple, Section 80. It says, evidence of an opinion is not inadmissible only because it is about a fact in issue or an ultimate issue or a matter of common knowledge. I mean, we see this a lot with the Uniform Evidence Act. It's almost a concession of saying, look, how do I put this? Can we just stop mucking around with so many small things? Can we just get on with it a bit? I like it. I like the approach. And it's saying, okay, if we're calling an expert, let the expert give evidence, even if it is to the ultimate issue. The jury doesn't have to accept it. The judge doesn't have to accept it, but let's hear what the expert has to say. So I kind of like it. All right, so that's all that I really want to talk for the moment about expert evidence, opinion evidence. Let's talk about opinion evidence of non-experts. And we've given some examples. Someone goes into the witness box and says, look, somebody looked angry. They talk about the weather. They talk about visibility being poor. In the cross-examination, or in the cross-examination exercise, people were asking me, when I was the witness, about the lighting, the traffic, whether my visibility was clear or not. I mean, I just answered those questions because that's what I saw, in my mind. But really, they're kind of an opinion, and we say you can have some latitude in that. And if you're really stuck for a submission or an answer to a judge as whether it should be allowed or not, I mean, maybe just go back and say it's graduated from the University of Life, Your Honour. That's not being disrespectful, but it's really just saying it's such a common knowledge matter that even if it is opinion, it still should be allowed. Now we see this with police officers a bit. They are entitled to say that someone appeared to be under the influence of liquor, correct? But you're also entitled to say, on what basis did you form that opinion? Because it's really an opinion. So we've heard, we hear the spiel, eyes were bloodshot, unsteady on the feet, speech was slurred, things of that nature. So that's all indicia that goes to support the opinion about the person being intoxicated or under the influence. But the police officer can't go this further step. This is totally inadmissible. The police officer can't then say, appeared to be under the influence of liquor, and therefore, in my opinion, was unfit to drive a motor vehicle. See, because that's drawing a conclusion, a legal opinion in relation to it. I mean, they say it, but you are entitled to challenge it and say, no, you're not allowed to give an opinion, which is really ultimately drawing a legal, proffering a legal opinion in relation to the evidence. Anyway, these are sort of fine lines. Now, I mentioned at the start that you need to consider the Uniform Civil Procedure rules. I'll just mention a few rules. I'm going to ask you to read these rules and be aware of them, because if there's an examination question about the provision of expert evidence in a civil trial in Queensland, you really need to know these rules. 423, 424, 426, 427, 428, 429. That's probably all you need to read. Let's just summarise what it means. This is all what we call Part 5. So the main purposes of Part 5 are to ensure that a witness who gives evidence as an expert does so in an impartial way and is not the expert for one side or not. And secondly, that there are rules put in place to ensure that we keep a cap on costs and we don't go silly about things. So, for example, Rule 423 provides that if practicable, and without compromising the interests of justice, expert evidence is given by one single expert, then that's fine. That's what we want. 424 says that it doesn't apply in certain circumstances. Now, 426 is key. This is the duty of an expert. The duty of an expert is to assist the court, and that duty overrides any obligation the witness may have to a party. So 426, UCPR 426 is critical. 427 deals with the way that experts provide a report, and it states in 427 that in giving evidence in chief, the expert can only do so by way of a report. So what does that mean in practice? You're acting for the plaintiff, you're trying to prove your case, you call an expert who gives expert evidence about weather conditions. You call them into the box, you say, what's your name, what's your address, what are your qualifications? Do you then ask them about the events of the 17th of November 2017 and the weather conditions? No, because that's the reason the expert is there. You have the expert tender the report as an exhibit and you basically sit down. That's the way it's supposed to work. You can only ask questions if you're doing so in response to another report or the court gives leave. You can be a little sneaky and try it, but really what's in the report is the evidence. It's a bit like the evidence in chief being provided in a family law proceedings or in other proceedings where the court has ordered that the evidence in chief be in the form of affidavits. Okay, so that's 427. 428 provides for the requirements of the report, and 429, I alluded at this before, is the disclosure obligation that a party intends to rely on a report has to disclose the report within 90 days, if you're a plaintiff, of closing the pleadings, or 120 days if you're the defendant. But otherwise you need the leave of the report. And 429B is that conclave provision. I'm not sure if it actually says that in the UCPR. I mean, that's what we call about. We call it a conclave, 429B. Let's have a quick look. Yeah, so 429B says the court may direct experts to meet. The court may at any stage of proceeding direct experts to meet, identify on matters where they agree, identify on matters where they disagree, the reasons why, and any attempt to resolve the disagreement. The court may set the agenda, specify the matters that they want the experts to discuss, direct whether legal reps may be present, give directions about the form of any report that's to be provided to the report, otherwise give directions, and evidence of anything done or said at the meeting is admissible at trial only if the parties agree. So what happens is in this conclave, it's like a mediation. So in QCAT tribunal I'm a member in, sometimes I will be the conciliator for an experts conclave. And what it means is that we have the experts come into a room and our role is to assist them to come up with a report which can then be used in a later trial. Okay, so have a look at 429B and also 429C deals with immunity. Any questions about that? All simple, easy? Good. Yes, Vivian?
These rules are from the, are they from the UCPR? Okay, yes, 1990, okay. Yes, okay. Okay, thank you.
You're on mute, John.
Sorry, thank you. Thank you. All right, so we've talked about civil experts. Let's talk about criminal for a moment. There is a rule that both Crown and Defence are required by law in criminal cases to disclose experts that they propose to lead giving evidence. So the general rule that Defence need not say anything and may remain mute won't apply if they have to give prior notice. And the reason for that's pretty simple, pretty sensible. If Crown are going to call an expert in relation to metadata on a computer and how it appears and disappears, you've got to let the Crown know so they've got a chance to prepare, ask some questions and check it out. The Crown has, in Queensland, special disclosure obligations under the Criminal Code. So it's another piece of legislation you need to be aware of. but only one section, section 590 AH. That provision provides a comprehensive list of the matters that the Crown must disclose, and they provide the time limits for doing so. All right, that's it for Queensland. Now let's talk about the Commonwealth. And you know, with evidence law, because we've got the dual regimes, we just keep bouncing between one to the other. So we're now back to the Evidence Act Commonwealth, Evidence Act 1995. Have a look at sections 76, 77, 78, 79 and 80. They deal with opinion. So section 76 deals with the opinion rule and goes through to section 80, which I've already addressed, which is talking about the ultimate issue rule and other rules. So section 76 is the core section. Basically, evidence of an opinion is not inadmissible to prove the existence of a fact about which the opinion was expressed. There are exceptions. Evidence relevant otherwise than as opinion evidence. There are exceptions. 78, dealing with lay opinions. 79, the exception opinions based on specialist knowledge. So it's more relaxed under the Commonwealth regime. So the key there is the default position, section 76, subsection 1. Now, to try and put all this in a little bit more context, let's talk about a very important piece of opinion evidence. And it's called identification evidence. So you might think that identifying someone when giving evidence is you giving evidence from your own senses, but really what you are doing is drawing a conclusion that the person that you saw on that day is the person who is now in the dock, the accused. It's really your opinion. And there are different types of identification evidence. There's recognition, resemblance, there's visual identification, picture identification, opinion evidence, descriptive evidence, and then there's in-court identification or doc identification, which is really pretty much useless. So when we talk about identification evidence, if you're answering a question in the exam about it, just be aware that there are different types of identification evidence. So you've got a few things to talk about there. The first general rule is this, and just think about this case. It's Alexander against the Queen. It's a High Court decision. It's 1981, 145 CLR at 395. And the simple proposition from Alexander's case is this: identification is notoriously uncertain. It depends on many variables. A little later, there was a High Court decision called Domican or Domican, depending on how you pronounce it. What happened is this. The witness and her husband were victims of an attack by a gunman. It was in the driveway of their own home. Could you imagine that? You've got someone wielding a gun, you're in the driveway, they're the victims. The witness didn't get a good look at the gunman, but gave various versions of identification at different times. And not surprisingly, her identification evidence was heavily discredited. So what that did was give rise to a new general rule that wherever identification is required or a significant factor of a Crown's case, then the jury should be given a warning, a Domican or Domican direction. And that really goes into the hazards of the identification process generally and any specific points of concern in the case. So that's the Domican direction, which deals with the unreliability generally of identification evidence. Now, I mentioned that there are a few other types of identification. One is picture identification evidence. And have a look at another piece of legislation. Section 617 of the Police Powers and Responsibilities Act, Queensland 2000. It provides for photo boards, videotapes, computer-generated images to be produced as part of the evidence. Okay. I know I'm moving quickly, but I'll lead you to flesh this out with your reading. Now, coming back to the Commonwealth legislation, I'm back to the Evidence Act 1995. So what are the sections that I want you to look at there when we're talking about identification evidence? Start with section 113. Now this is part 3.9. Now this only applies to criminal proceedings, this part. In 114 it talks about visual identification. And the basic rule is this: visual identification evidence adduced by a prosecutor is not admissible unless an identification parade that includes the defendant has been held before the identification was made, or it would not have been reasonable to hold such a parade, or the defendant refused to take part in the parade, and the identification was made without the person who made it having been intentionally influenced to identify the defendant. So that basically sets some rules to the identification process, which is visual. Have a look at section 115. In the Commonwealth sphere, picture identification evidence is not admissible. So there is no counterpart to the Police Powers and Responsibilities Act. And in 116, it talks about directions to the jury, and this is really at the heart of the Domican direction. And it talks specifically about the need for caution before accepting identification evidence and the reasons why there is need for caution, both generally and in the circumstances of the case. So that's straight Domican or Domican direction. So that's part of the Evidence Act 116. We don't have a counterpart for that in our Queensland legislation. All right, so any questions then so far? We're doing okay? Yes, Vivian?
Section 590 in the Criminal Code, Queensland, is it 1899?
Section 590AH, from memory?
Yes, that's the Criminal Code of Queensland. That's the one of 1899, right?
Oh, yes, the Criminal Code. So it's it's actually a schedule to the Criminal Code Act, but yeah, it's the Queensland Criminal Code. I don't have one with me at the moment, but it's about as thick, it's about as big as the UCPR. So you got that? So thank you, Vivian. All right, so what we've been talking about so far, amongst other things, is the need for warnings to be given in appropriate circumstances about identification evidence which is notoriously unreliable. There are historically and still currently, to some degree, other warnings that might be given about unreliable evidence, such as evidence that was uncorroborated, complaints in sexual assault cases, accomplices, child witnesses. Now, historically, have a look at Bromley against the Queen in that regard, which provides the early basis for making those statements. But that was extended, if you like, in Longman against the Queen. Longman's an important case because it talks about the warnings that must be given to a jury in certain circumstances, particularly where there is a long delay between alleged incident and the trial of the matter. And it's essentially saying, you know, it's pretty hard on defence to be able to identify what they might have been doing, the circumstances. There might have been witnesses around that, had they been charged immediately, they could have accessed those witnesses. Now, all of that valuable evidence is lost because of time. We're not saying, I mean, in a Longman direction, we're not saying that the quality of the complaint is any less than it would have been had the complaint been made at the time. What we are saying is, you take that into account, but just weigh it up against the fact that defence may not be able to access the evidence that they once could have had if the complaint had been brought straight away. I hope that makes sense. Now, I mentioned corroboration. I mean, that was a historical rule. Have a look at the Criminal Code again, section 632, because there is now no longer any mandatory requirement for corroboration, other than a few things like perjury. So the general rule is that a person may be convicted on uncorroborated testimony of a single witness. Historically, that wasn't the case. There are some exceptions. Juries need to be very careful about this. One of the exceptions is the McKinney direction, which is where the allegation that police verballed a confession whilst in police custody, and the Domican direction that I talked about, and a jail guard confession is another one. All right, so I won't mention any more, but from that, do look at the Domican direction or Domican direction, look at the Longman direction, and think about the provisions in the Criminal Code and the Evidence Act, Commonwealth and State. All right, you're doing very well. You're hanging in there. Just in terms of Commonwealth again, a few other sections which deals with corroboration. Have a look at section 165 of the Evidence Act, and 164 and then 165 of the Evidence Act Commonwealth. So I'm back to the Commonwealth Act. 164, like the Queensland provision, corroboration requirements have been abolished under the Uniform Evidence Act. That's 164. And then, you know, we're talking about the warnings, information, unreliable evidence in common law and under the Queensland regime. That's catered for in section 165 of the Commonwealth Evidence Act, which deals with warnings and information regarding potentially unreliable evidence. And some of these are similar to what we talked about before. For example, 165B deals specifically with the issue of delay in prosecution, and that's pretty much Longman. Again, it only applies in criminal proceedings, and it says in subsection 2, if a court on application by a defendant is satisfied that the defendant has suffered a significant forensic disadvantage because of the consequences of the delay, the court must inform the jury of the nature of the disadvantage and the need to take that disadvantage into account when considering the evidence. Okay, the judge need not comply with that subsection if there are good reasons for doing so. But basically, 165B2 is pretty much Longman. Okay, are you doing well? I think that will probably cover everything we need to cover for tonight. Are there any questions? Big nod there from Samantha. All good? Next week's our last week. So we're talking about criminal proceedings, but I'll move through that pretty quickly so we can talk more about the exam. Speaking of which, do you have any questions about the exam? And I guess you want to know when you're getting your results back from the second assessment, which will hopefully be, early next week. Yes, Vivian?
Yes, for the exams, are we going to write it at the uni?
What was that, sorry?
The exams on the 4th of June, are we going to write it at the university campus?
Now, thank you. That's a really good question.
Yeah, thank you.
The answer is yes, this is an invigilated examination. So it's not an online exam. It's not one that you do at your computer. You need to be at an examination centre. Now, that means everyone potentially will be at a different place for the examination. A few of you might be at the same place, but the university stress this for me and other unit coordinators. They say, be very careful about the advice that you give to students regarding the time and place of the examination, because potentially they're different. So you need to look on, now, what is it called? My CQU? My Centre. Thank you, Samantha. So Samantha says the locations are posted. It should be on your My Centre. Is that's what it's called, Samantha? No, My CQU. My CQU. I thought it was something like that. I think I may have posted something about that, but I don't have access to your individual records. So you need to look that up for yourself. So Vivian, are you familiar with the My CQU? Right. So according to Samantha, it should confirm the time. I'm just indicating what I think the time and date is, but you should confirm that for yourself. And also it should have the location. Get there early. Make sure you don't take anything into the examination that would allow you to have access to the internet, because you can't do that. Other than that, what can you take in? What do you think is the most important things to take in? The Evidence Act, yes. More important than that, have you seen my level 3 preparation for examinations video? Have you watched that? Because if you've watched that, you'll know what the answer is, according to me. The answer is your own answers to the questions that you think will be on the examination. So, for example, tonight we've talked about opinion evidence. I would expect that you'll have mapped out, at least in point form, your logic in how to explain opinion evidence. Now, it's relatively easy to do this for the examination because there are no problems on this one. You've had enough problem solving, experiential, practical type assessment. This is straight essay stuff. So it will be, you know, explain opinion evidence and the shortcomings of opinion evidence in terms of identification or whatever it might be. That's not meant to be a hint. That was just me saying something off the top of my head. But you can take in everything you want. It's opinion evidence. It's written examination in essay form, and you can write the answers if you think you know what the questions are. That was a very long answer to a simple question, Vivian, sorry. And in the end, I didn't even answer your question.
The Evidence Act, 1977, Queensland. I don't have a copy. Should I check at the bookshop? I think they should have it at the uni bookshop.
Yeah. Look, I actually, we used to go to a place called GoPrint, but they closed it down. I forget where I actually paid for this to be bound. So I've got one of these, and I've got the UCPR, and I've got a whole bunch of other things that I got them bound up so I can take them into court. But you can print them off the internet.
Oh, okay.
Or, you know, you don't necessarily have to print the whole thing. You can just extract those sections that you think are relevant. Another thing that you could do is print the index, so at least you've got the section numbers. But yeah, one of those options.
Okay.
If you want to buy the bound version, it might be a little bit late, but I think they take a week or so. So we've still got time. But whether you want to spend the money to get that professionally bound version is a matter for you. Sorry. So Samantha said just printed it and bound it. Yeah, that's what you were showing us before, Samantha. Okay, so that's another one.
Yeah, I just printed mine and used like one of those old binders.
Okay, yeah. Which is fine. All right. Now, any other questions at this stage? And we will talk more specifically about the exam next week. All good? Okay. All right. Well, thank you for attending. We really appreciate it. We'll see you next week. Any questions, ask through you, crew. All the best. Bye then.